Picture this, you just finished the job, crew did great work, client seemed happy the whole way through, everything went smoothly on site. And then the final invoice goes out and suddenly the client has questions. Things that were never in the original scope are now apparently things you promised. The price they remember agreeing to is somehow different from the one you quoted. And when you go to find something in writing to back yourself up, there's nothing there. Just a handshake, a good feeling, and a very expensive problem. I've sat with contractors who lost 30, 50,000, even more because nothing was documented properly before the job started. And by the time the dispute happened, it was their word against the client's with no paper trail to settle it. That's what a missing or weak contract actually costs. Not in theory, in real money, real stress, and real time spent trying to recover something that should have been protected from day one. Last month, I sat down with a construction lawyer, and today I am sharing with you everything I've learned from him. I've worked with hundreds of contractors for the last 7 years, so I know a thing or two about what works and what doesn't, and what normally costs contractors serious cash when contracts aren't done right. Today, I'm walking through exactly what a solid construction contract needs to cover so that the next time a client tries to change the story at the end of the job, you have something that tells it for you. I work with construction business owners on their finances every single day. And one of the patterns I see constantly is this. The contractors who are the most stressed about cash flow, who have the most trouble collecting, who end up in the most uncomfortable client situations are almost always the ones whose contracts are either missing entirely or so vague that they're basically impossible to enforce. A handshake feels completely fine when the job goes well, and lots of jobs do go well, don't get me wrong, but when something does go sideways, and at some point something always does, the contract is the only thing standing between you and a situation that could cost you tens of thousands of dollars and months of your time. So let's talk about what a solid construction contract actually needs to cover. Here is something that surprises most people when I tell them this. The most common contract mistake I see isn't having no contract at all. It's having a contract that looks totally fine until the moment you actually need it, and then you find out it doesn't protect you the way you thought it did. Verbal agreements, something downloaded from the internet years ago, or maybe even a template a friend passed along, these all feel like enough until something goes sideways, and you don't find out what's missing until it's too late to fix it. A contract doesn't mean you don't trust your clients. It means everyone knows what was agreed to before anyone shows up on site. Payment terms. This is the section that has the most direct impact on your cash flow, and it's the one most contractors either rush through or leave dangerously vague. Let me walk you through what it actually needs to cover. First, a deposit before your work starts. The percentage can vary depending on the size and type of job, but something upfront is not optional. It protects you from a client who changes their mind after you've already mobilized your crew and ordered materials. It also gives you something to work with before your own costs start going out the door. Second, a milestone payment schedule tied to specific phases of the work, not general progress payments, specific milestones with specific triggers. Foundations complete, interior roughing complete, whatever makes sense for how your jobs run. The point is that there's a clear defined moment when each payment is due, so nobody can claim they didn't know. Third one, and this is the critical one, what happens when a milestone payment doesn't show up? Is there a grace period, a stop work clause? What's the exact process? Because if your contract doesn't answer those questions, the client fills in the blanks themselves and almost never in your favor. Fourth, a late fee structure with real teeth. 1.5% monthly fee for a 60-day overdue doesn't make anyone move faster. The fee needs to be meaningful enough that paying on time is genuinely the smarter financial choice for the client. And fifth, a clear definition of when final payment is due. On completion, not whenever a client feels ready, and not after they've had some time to think about it. On completion. I had a contractor whose client called mid-projects and said they were running a little behind on the milestone payment, but asked if the crew could keep going in the meantime. And because his contract had no stop work language, he didn't feel like he had a clear basis to actually stop. So the crew stayed on site for 3 weeks without a single payment coming in. By the time the situation got resolved, he had 3 weeks of labor costs and materials out of pocket with no real guarantee of when any of it was coming back. All because the contract didn't give him a framework for what to do when the payment didn't show up on time. One clause, 3 weeks of cash flow stress. That's how much those details matter. Lien rights. So most contractors either don't know about this or know about it and never actually use it, which is a shame because it's genuinely one of the most powerful protections available to anyone doing construction work. A lien is a legal claim against a property. When it's in place, the property can't be sold or refinanced until the outstanding debt is cleared. It's the thing that gets even the most stubborn, non-paying clients to suddenly find the money. Most states allow contractors to file what's called a pre-lien notice early in the project. Filing that notice doesn't mean you're threatening anyone and that you expect a problem. It just means you're protecting your right to place a lien later if payment becomes an issue. Think of it like insurance you put in place before you need it. The dynamic on a job shifts when the client knows you understand your lien rights and you're prepared to use them. Large GCs and developers who will delay payment indefinitely when there's no pressure, to move quickly, this is what you do. I have situations where contractors couldn't get any response on an outstanding collection for months. Filed a lien notice, had full payment within a week. Every state has different rules around liens, different deadlines, different notice requirements. This is worth understanding for your specific state before you ever need it, because once you are in a dispute, it's not the time to try to figure out this process from scratch. Change orders. Every contractor knows scope creep is real. Clients add things, the plan evolves. That's just construction. What separates the contractors who get paid properly for all of that extra work from the ones who absorb it silently is one thing: whether they have a real change order process or not. Every change to the original scope needs a written change order signed before the work starts, not after it's done as a formality, not as a catch-up at the end of the project, before anyone touches anything that wasn't in the original agreement. That change order needs to capture three things: what's being added, what it costs, and how it affects timeline. All three, because adding scope almost always pushes the schedule, and if that's not documented, the client is going to expect the original completion date to hold no matter how much was added along the way. Verbal approvals are not approvals. A client saying, "Yeah, go ahead," while walking past you on the job site is not a signed change order. And when the final invoice comes in higher than the original contract number, that casual conversation is going to be very hard to prove it ever happened. When a client pushes back on signing a change order because it feels like too much paperwork, a simple response works really well. You can tell them you completely get it and that the change order actually protects both of you. It makes sure everyone is clear on what was added and what it costs, so there are no surprises when the final invoice comes out. The clients who genuinely trust you sign it without any drama. The ones who resist hard are usually giving you early information about how the rest of the job is going to feel. Dispute resolution and termination. Nobody starts a job expecting it to end in a dispute, but the contracts that handle dispute well are actually the ones that prevent disputes from escalating in the first place. Your contract needs to define what happens when there's a disagreement. Who reaches out first? Is there a mediation step before anything escalates to litigation? What does that timeline look like? Mediation language matters a lot here. Litigation is slow, expensive, and almost always worse for both sides than sitting down and working something out with a neutral third party. When both parties have agreed upfront in the contract to try mediation first, it removes a lot of the heat from early disputes and gives both sides a path that doesn't immediately cost a fortune. The contract also needs to address what happens if the relationship completely breaks down and the work stops mid-project. Who owns the work that's been completed? What's owed for the labor and materials that have already gone in? How does the handover happen? These are uncomfortable things to think about at the start of a job when everything feels positive and the relationship is good, but having these answers defined in advance is actually what makes it possible to handle them calmly if things ever go wrong. And sometimes they do. Every situation I walk through today, the client who adds work and then doesn't want to pay for it, the milestone payment that never shows up, the final invoice that gets disputed, the collection that drags on for months with no resolution, all of it gets significantly harder to deal with when the right contract language isn't already in place. A solid contract isn't a signal that you don't trust people you work with. It's a signal that you run a serious professional business where everyone knows exactly what was agreed to before a single tool hits the job site. The best clients actually respect that. It makes them feel like they're working with someone who has their act together. If you haven't had a construction attorney review your current contract, that conversation is worth having. The cost of one review is genuinely nothing compared to the cost of the bad job that had no real protection underneath it. And if you want help understanding how your contracts are affecting your cash flow, your margins, and overall financial health of the business, that's exactly what we do at Beyond Book Solutions. Link to book a call is in the description. If this was helpful, share it with a contractor who needs to hear it. There are a lot of good people out there doing really solid work who are one bad client situation away from a very expensive lesson. I'll see you in the next one.